Hi guys! Am I live? I think we're back. So if you've missed it, YouTube has not loved me lately. I've had 2 restrictions. One, I got an explanation that I was apparently moving or transporting or using a pew-pew on live stream, which was not true. It was not happening. I don't even want to describe it on stream in case their AI thinks I'm doing it supposedly again. And then after that was lifted, did a live stream, no issues, everything was fine, it's still up. And suddenly I couldn't go live the day after that, and I had what seems to be a 48-hour restriction with no explanation. And none of the channels that I contacted to try to get through to YouTube through chat, through email, through the Creator Studio back end, they would do these, we'll escalate it and promise someone will get back to you. Not a single response through any of those attempts. So hopefully we're good to go today. Let's get the chat on the screen. If you are here watching live, run the chat up. There we go. Got you guys on here. Good to see everybody. We are here today. It's like as soon as YouTube restricted me, like 30 different things started happening, of course. And like 3 of those 30 things involve Tyrone Blackburn. So we're going to do a stream on Tyrone Blackburn, his case with Fat Joe, and we're going to look at one other case real quick. I spoke the other day about the ongoing dispute with Nantongo v. Nationwide Insurance, where Tyrone Blackburn had 2 co-counsel. They were all representing the plaintiff, Nantongo, Olivia Nantongo. And there was a settlement in that case that Olivia Nantongo purportedly accepted. The court accepted it back in 2024. And that was the end of the case, or so it seemed. But now, suddenly, Tyrone Blackburn is accusing his 2 co-counsel of fraud, forgery, saying that that wasn't actually Olivia Nantongo signing off on that settlement, even though he would have been counsel of record at the time. We're going to look at one bit of that, but we're not going to start reading the docket today. So that's going to be a separate stream, maybe later tonight, but probably later this week. And then tomorrow we'll be back for Julio Fulio trial, day 3. So let's get into it, you guys. First, remember that there were multiple sanctions requests happening in this Fat Joe, Joseph Cartagena case against Terrence Dixon, Tyrone Blackburn, and Blackburn's law firm. Those are the 3 defendants. The longest, outstanding sanctions motion when Judge Jennifer Rochon, transferred this case to Judge Jennifer Willis. She was like, I'm going to retain this issue at docket item number, 1 something. It's the sanction motion that's outstanding. It's a request by Fat Joe's team for sanctions and to recover costs for Terrence Dixon and Tyrone Blackburn not showing up for their February 6th and February 9th depositions. So we finally have a decision come through on that. You'll see this is dated the 24th. So it's from Judge Jennifer Rochon, the old judge, on January 20th, 2026, after a conference with the parties. Now remember these dates, right? This is right before his first procedure that Tyrone Blackburn says he had. January 20th, after a conference with the parties, the court ordered that the depositions of defendants take place on February 6th and February 9th based on defendants' counsel's representations to his availability. So she cites 2 different docket numbers, 3 actually, with a quote, I will not be available to sit for a deposition until February 6, 2026. I believe this was a transcript attached. And February 9th, 2026. Notwithstanding this order, defense counsel emailed plaintiff on February 3rd, 2026, that he would not be attending the depositions on February 6th or 9th. So we get this court order on January 20th, after a conference where it was verbally agreed to by Tyrone Blackburn that he'd be available to sit on the 6th and the 9th. Then 3 days before this first deposition, Tyrone Blackburn emails Fat Joe's counsel. Doesn't contact the court, but emails Fat Joe's counsel. And says, hey, I'm not going to be attending either of those depositions, and I would seek relief from the court that day. He told Fat Joe's counsel, I'll let the court know. Contrary to this communication, defendants did not contact the court on February 3rd to seek relief from the January 20th, 2026 order, or otherwise inform the court that defendants could not attend the depositions. Only after plaintiff moved to compel compliance with the court-ordered deposition dates on February 5th, 2026, did defendants inform the court that they would not attend the ordered deposition dates. So Fat Joe's like, hey, it's been 2 days since Tyrone Blackburn told us he would tell you that he's not going to sit for the depositions he told you he would sit for, and you ordered him to. So we're letting you know because the depositions are scheduled for tomorrow. We don't want to look like we missed our opportunity to do these depositions. You've already extended the discovery deadline for us to make this happen, and we don't want to lose our shot to get information that could help our case. So they email, and the court's like, yeah, Blackburn, you told them you'd email me, and you didn't. Without receiving relief from the court, defendants did not appear for the court-ordered depositions on February 6th or 9th. The court reporter and videographers were present for both scheduled deposition dates, and plaintiff's counsel placed on the record that defendants had not appeared. And they're citing here, I believe they uploaded the transcripts from those hearings, where they were like a couple pages long, and it's just like Takapina or who knows who, saying, it is this time, we'll note for the record that the deponent is not present. And then they end for the day. The court ultimately held a hearing on the matter on February 10th, rescheduled the deposition dates, and ordered that the parties more fully brief the plaintiff request at docket 143 for sanctions in order to provide defendants an opportunity to respond. Any motion for sanctions was to be filed by February 13th, and defendants were ordered to respond by February 24th. So here we go. They're on notice. The defendants, I'm going to request Fat Joe's team, tell me what sanctions you're looking for, and you guys need to respond. So plaintiff files on time. Fat Joe files on time. And let's see. And what they were seeking was the costs and fees, a referral of defense counsel Tyrone Blackburn to the Committee on Grievances of the Southern District of New York, and the third thing, an order that Blackburn serve any sanctions determination on his client, Terrence Dixon. And it says, and another letter he filed in another matter. So I think this is relating to the representations in Judge Semper's case in New Jersey. And Fat Joe's team had asked something like, can you require Tyrone Blackburn to inform his client of the hot mess he's getting himself into, if he hasn't already disclosed this mess to his client? So defendants did not respond, neither of them. So remember, since Tyrone Blackburn's a defendant here, he has to respond for himself. But he's also, and his law firm's a defendant, they're both the one representing Terrence Dixon. They should have a duty to, like, a fiduciary duty to their client. You would think that they would file a response on behalf of Terrence Dixon. But defendants did not respond by the court-ordered deadline. On February 27th, plaintiff filed a letter in further support of his motion for contempt and sanctions, noting that his motion was unopposed. So only later on March 2nd did defendants respond to plaintiff's motion. So they're late. Under Federal Rule of Civil Procedure 37B, failure to appear for a court-ordered deposition may be treated as contempt of court. A variety of sanctions may be ordered, and the court must order the disobedient party or attorney to pay reasonable expenses, and this is worded, the court must order the disobedient party or attorney to pay reasonable expenses caused by the failure, unless the failure was substantially justified or other circumstances make an award of expenses unjust. Now, the reason I'm highlighting this is I think Judge Jennifer Rochon has given 100 chances. She's this is your last warning. And then the last warning never comes. So here's statutory language where, unless something's justified, or there's other circumstances that would make this award unjust, the court must order reasonable expenses caused by your failure to show up for the deposition. And this is the very narrow punishment that Judge Rochon is going to grant against the defendants. The court has broad discretion to determine the type of sanction to impose upon a party based on all the facts of the case. When determining whether to impose sanctions, a district court considers the following non-exhaustive and non-exclusive factors. So you've got 1, the willfulness of the non-compliant party or the reason for noncompliance. 2, the efficacy of lesser sanctions. 3, the duration of the period of noncompliance. And 4, whether the noncompliant party had been warned of the consequences of noncompliance. And then they quote here a case that says, prejudice to the moving party is also a relevant factor. So here's what she decides. And I want you to put on your Tyrone Blackburn hat and imagine how Tyrone Blackburn's going to try to interpret this based on if you've gone through his opposition to Fat Joe's motion for sanctions in relation to the deposition behavior, that outstanding motion for sanctions, and his request for cross sanctions. He was like, oh, the court judicially determined that my medical emergency was justified and granted me relief. And Fat Joe's team has disputed that that's what the court found. But think about how Tyrone Blackburn will interpret this. After considering the parties' submissions, the court will hold defendants in contempt for failing to appear. So that's what she's doing. You're in contempt because you didn't show up for these court-ordered depositions on the 6th and the 9th. However, she says, after weighing the facts and the circumstances here, including the factors set forth above, the court will not impose the sanctions requested by the plaintiff because of the medical issues cited by the plaintiff, and will not award the attorney's fees requested by plaintiff, given that the time spent preparing for the depositions will be directed toward the rescheduled depositions. However, plaintiff incurred the cost of a videographer and court reporter for the depositions because defendants did not timely obtain relief. Therefore, defendants are ordered to pay just that part. The reasonable costs incurred to pay the videographer and court reporter for February 6th and February 9th. Plaintiff shall promptly produce to defendants proof of costs incurred for the videographer and court reporter, and defendants are ordered to reimburse plaintiff for those costs within 10 days of receipt of those invoices. So that's Judge Jennifer's Rochon's decision on the older outstanding motion for sanctions related to the failure to appear. So I'm going to hold you in contempt. You've got to pay the nominal-ish fees for just the 6th and the 9th, and that's it. And then there's this phrase, because of the medical issues cited by plaintiff. So, I know Tyrone Blackburn's going to jump on that. You know what my response would be if he chooses to jump on that and say Judge Rochon found his medical claims to be credible at face value? Well, above we have this. If she found that these medical excuses were credible, I don't think any expenses would have been warranted at all. Because she is finding that the failure to appear was not just. So, I bet we're going to see a little bit of sparring about that in the future. So again, that's her order that came down. We also have from Judge Jennifer Willis just some scheduling. So I don't see like a public listen-in line for this. This seems like it's going to be an in-person hearing. But Judge Jennifer Willis, the new judge that this has been transferred to, says the court is in receipt of plaintiff's motions for sanctions. This is the bulky cross motion for sanctions, all of that about the behavior at the depositions. The court is also in receipt of depositions cross motion for sanctions in opposition to plaintiff's motion for sanctions, and plaintiff's opposition to defendant's motion for cross sanctions, and reply to defendant's opposition on the plaintiff's motion for sanctions. Any reply to defendants to plaintiff's opposition to the cross motion for sanctions must be filed by April 22nd, 2026. No other briefing may be filed. Now, I checked this on the 23rd. Nothing was filed. Tyrone Blackburn ends up filing this late. On the 24th, 2 different documents come through, although one is dated for the 23rd. But that would make it late. So we get late filings here, despite this. The court will hear oral arguments on both motions for sanctions on May 18th, 2026 at 2 p.m., and the hearing will take place in courtroom 228 at the Thurgood Marshall United States Courthouse. So that seems like it's going to be in person and not a virtual conference. So we'll have to see if we could figure out what happens. Now, while we have this, right, I was reading this over the weekend. I'm like, oh, I was tweeting because I couldn't go live. I'm like, hey, it looks like Tyrone Blackburn's late. So ... /star is like, well, I think that's because he's too busy filing this other thing. And let's pull that up. That will be our quick little blurb on the Nantongo case that we're going to do a deep dive on another day. Let's see. So I'm like, oh, he appears to be late. Right? Here we go. No reply has been filed yet. Appears to be late. ... /star the goat says, of course, he's too busy building, I don't know how to say words, trebuchets, I don't know, elsewhere in his glass house. So he sends this little snippet, and we're going to read more of the filings in full in another stream. But he highlights here that the time this is from Tyrone Blackburn, some filing that Tyrone Blackburn submitted in the Nantongo case. The time I expended investigating and responding to the fabricated and misattributed citations in 2 different filings by Fred Charles was not less than 10 hours at my standard hourly rate of $750 per hour, with the double highlight, for a total of $7,500 in fees and costs attributable solely to addressing Mr. Charles's conduct. So his hourly rate is $750 an hour. And he's also busy writing all of this stuff, even though he's missing deadlines in another case. So I'm like, wait, is that the Nantongo case? Oh, I went and looked. And what I thought was interesting during this is he's filing all of these things in the Nantongo case. I started looking back through the docket. And let me show you the docket. Or we'll get into it, but I thought I had a quote with it. He was doing a bunch of filings and sending a bunch of emails and group texts and doing a bunch of stuff in relation to Fred Charles and this Olivia Nantongo case, creating WhatsApp messages all around the same dates of the end of January and beginning of February, where in recent depositions, he's claiming he wasn't himself because he was on a narcotics regimen. And before the narcotics regimen was the problem, that he was unavailable because of the procedures themselves or other personal family emergencies. But meanwhile, according to exhibits that are popping up in this Nantongo case, Fred Charles filed this as part of one of his filings to show that, in his opinion, Tyrone Blackburn's been off his rocker for a few months. And so this is messages that, and I love the profile picture, that Fred Charles received from Tyrone Blackburn back in January. Good morning, Fred. I hope this finds you doing well. If you don't already have it, I strongly recommend that you obtain malpractice insurance. I will give you 30 days starting today to get your affairs in order. He has not yet filed this, motion to vacate the judgment in the Olivia Nantongo case alleging the fraud yet. So there isn't litigation relating to his claims here. But right before he makes that filing, he's sending these text messages that very much remind me of what we're hearing about in the Fat Joe case, where he's contacting Erica Morera and saying, here's a new version of the complaint if you don't meet our demands. And he's saying it was just a request for friendly conversation. If you don't meet our demands, we're going to file this. We're going to go public. He's texting this to his co-counsel for Olivia Nantongo over a year after the settlement. Strongly recommend that you obtain malpractice insurance. I'll give you 30 days starting today to get your affairs in order. I recommend CNA or Chubb. You should get a policy with a very high payout. You will need it, and you can thank your big brother Ralph. And then he attaches his own reaction to himself and says, 2 Charles for the price of 1. So I was like, okay, whatever. I'm just looking at this. And that's when I realized I pulled up the docket. He filed it before the motion to vacate. 2 days after he ends up filing the motion, he's emailing an attorney that attorney Fred Charles works with on another case, isn't part of the Olivia Nantongo case at all, and is like, hey, just want to put you on notice, and sends a whole email saying, do you know Fred Charles? And his other co-counsel on the Olivia Nantongo case committed fraud and forgery. And is just emailing another attorney, waiving his claims about the forged signature to someone else that's working with Fred on another case. So we're going to do a deep dive on that. But this is all during the time period where he's supposed to have his first surgery. Because this is sent before January 23rd. And then the email after he does the filing on like January 24th, the email is dated January 26th. So all of this time where he's so busy and having these procedures where he can't do things in the Fat Joe case, this is what he seems to be busy doing. I think that's a problem. I think that makes me skeptical of any of his claims anywhere. And it gives weight to what Fat Joe's claiming against him, and it gives weight to what Fred Charles is saying is his defense. Like, I didn't forge Olivia's signature. I'm getting these weird messages that seem to just be a group WhatsApp, where I don't really know if that's even Olivia in the WhatsApp, because that person seems to be speaking exactly like how Tyrone Blackburn speaks. And it's just a WhatsApp group message, not a phone call with a voice or anything with wet ink on paper. So, in addition to that, that's not it before we get back to the Fat Joe case. The Diddy docket over on X was like, just posted a blurb because it's a Jane Doe and Combs case. And they just posted this blurb. So this blurb that they posted, because you can't get it, it's just a text order. It says, order terminating letter motion for extension of time to file. The court will consider plaintiff's untimely opposition in ruling on defendant's motion to dismiss. The parties are on notice that failure to comply with court orders and all applicable procedural rules may result in sanctions, including monetary sanctions on counsel and the parties themselves, preclusion of claims, and that's a severe sanction. So this is a big warning. Preclusion of claims, defenses, evidence, and motion practice, and the case terminating sanctions of dismissal for failure to prosecute and default judgment. Plaintiff personally is on notice that he is ultimately responsible for prosecuting his case, which may be dismissed or otherwise adversely affected because of his chosen counsel's failure to prosecute. So the judge is taking the time here and saying, plaintiff, you might be here on good terms with a good claim in good faith, but I really need to put you on notice that the plaintiff here in this case who's suing Combs, it's a John Doe, I think, is it named? I think the person's named in this one, is ultimately responsible for prosecuting the case. So if your attorney sucks, your case could still be dismissed or adversely affected because of your chosen counsel's failure to prosecute or failure to comply with court orders and applicable rules. Plaintiff's counsel shall inform his client of this warning. So this is ordered by Judge Mary K. Viscoso. And it reminds me of Fat Joe's request as part of his sanctions request. Make counsel Tyrone Blackburn inform his client, Terrence Dixon, of these other matters, these other issues. So when I saw this posted by the Diddy docket over on X, I'm like, let me check. So I pulled up this court listener docket. It's Burroughs v. Combs. I'm like, I know Tyrone Blackburn has a bunch of clients that are suing Diddy. And sure enough, whose name do you think is here representing the plaintiff? So, sure enough, it is none other than Tyrone Blackburn.
So many cases, I don't know. I just can't it's like a lot of cases.
In so many cases, his name popping up. So he's on notice in another court. I wouldn't be surprised if we see this looped in on some other court's motion, ongoing requests, or arguments against Tyrone Blackburn for one thing or another. And then going back to Fat Joe, we're going to get into some meat and potatoes. That's just some orders and decisions coming down that relate. But we've got here some docket activity. So again, even though there was a deadline for a reply to, because remember, Tyrone Blackburn ends up filing a cross motion for sanctions. Last week we got together and we read Jordan Siev put together all those tables, side-by-side comparisons of claims versus what the record reflects. So we had like the table comparison by Jordan Siev. We read through all of those. That was the response to the cross motion for sanctions. Now, we had the deadline of April 22nd for Tyrone Blackburn to reply to the opposition. So let's look at that. We've got a declaration and his actual reply. Close some tabs here. We'll start with the declaration. We've got, and again, filed late. I am the principal attorney of T.A. Blackburn Law and a named defendant in this action. I submit this declaration in response to the personal attacks, false characterizations, and irrelevant innuendo contained in plaintiff's opposition papers. Plaintiff's counsel has introduced into the record a series of misstatements about my medical condition, a prepaid personal trip, my litigation activity and other matters, and an alleged recreational trip to Trinidad. So he's separating this. He's saying a prepaid personal trip and an alleged recreational trip to Trinidad. And even though he's saying it's alleged, he then says none of that has any bearing on the legal question before this court. I address in turn under oath so that the record reflects the truth. On January 23rd, 2026, I underwent a medical procedure performed by my treating physician. This is Jason Emmer. Let's see. If you guys missed all of that and need a quick summary, we read through one of the deposition testimonies where Joe Tacopina goes through and is like, this is his website. He pulls up the website during the deposition. What procedure did you get? What were you prescribed that you're using as an excuse for why you can't do certain things? Was it this procedure? Was it this procedure? Was it any of these procedures? Was it any of these procedures? Was it any of these procedures? And all the way through, it's, I don't recall. So there's that. That's what we're talking about here. On January 23rd, 2026, I underwent a medical procedure performed by my treating physician. A further procedure was performed on February 3rd, 2026. Both procedures were medically necessary. The nature of my medical care is a private matter protected by well-established principles of medical privacy. Plaintiff's characterization of my procedures in his papers is not only factually inaccurate, it is gratuitous, irrelevant to any legal issue in this case, and appears designed to exclusively embarrass me and to generate material for media outlets sympathetic to plaintiff. The specific nature of the procedures I underwent has no bearing whatsoever on the conduct of counsel at any deposition in this case, except it's directly relevant because this was his cited basis for saying he wouldn't show up for the 6th and the 9th, and then it became the basis for which he excused his conduct at the later rescheduled depositions on February 24th and March 6th. So it's very relevant because he's leaned on it as his shield. Plaintiff's references to my surgeries serve no legitimate litigation purpose and warrant no further dignity from this court. Following my procedures, I was prescribed pain management medication by my treating physician. I'm not a person who regularly consumes alcohol, narcotics, or other mind-altering substances. As a result, the pharmacological effects of this medication on me were more pronounced than they would be on a person with a different tolerance history. I have pharmacy records and a written prescription from my treating provider confirming the name, dosage, and duration of my treatment regimen, which I'm prepared to produce at an evidentiary hearing if the court so directs. I mean, I believe at this point, maybe there was already a sanctions. He could have just said, I'll present at the hearing on May 18th. The February 24th, 2026 deposition of Terrence Dixon occurred just 21 days after my second procedure on February 3rd, 2026, while I was still within my post-surgical recovery period and actively taking prescribed medication. He never asked the court or told the court, hey, I'm on this medication, can we reschedule this deposition? Plaintiff's characterization that I, quote, falsely blamed my medication for my demeanor at that deposition is both inaccurate and unsupported. Plaintiff's assertion that I falsely blamed, in single quotes this time, my medication is not based on any medical evidence, expert opinion, or contemporaneous documentation in his possession. It is pure speculation offered as established fact. Court... What's so funny is Fat Joe's team in their reply they argued that I forget how they worded it, but like their narcotic regimen defense, they had like a phrase that they kept repeating, and they used the same phrase every time they mentioned it. They're like, the narcotic regimen defense that Tyrone Blackburn's trying to put forth is not based on any medical evidence, any expert opinion, or contemporaneous documentation. That was Fat Joe's argument. And now somehow Blackburn's responding by saying, in a declaration, the plaintiff's assertion that I falsely blamed is not based on any medical evidence. You're the one that's supposed to provide it and support your excuse. So they say it's pure speculation offered as established fact. Courts in this circuit have held that sworn statements regarding impairment should not be rejected in favor of speculation, absent actual evidence contradicting the claimed impairment. I want to see. So this looks like Minnesota versus Target. I want to look at this actually, because I wonder if this is like, if somebody's claiming that somebody's impaired. Like, let's say this Target case is about an accident happened at Target. The Target employee was either fired and or wanted a workers' comp claim, and the Target store said, you know what, actually, you were impaired, so this was your fault. You're not eligible for a workers' comp claim because this was you. You were impaired at work and you fell off a ladder. It's different. I wonder if he's taking that and trying to apply it if somebody says his claims are not true, which is a different claim. If I'm making the claim that somebody's impaired, I'm the one initiating that claim. I have a certain burden that I've got to meet to back up my claim. But if I'm claiming, hey, I know that the other party's saying I engage in inexcusable behavior at these two depositions, but I have an excuse. It's not the other party's burden to like produce medical paperwork and medical evidence about your medical excuse that you brought up. Like, what are we doing? So they say plaintiff has offered no such evidence. His characterization is accordingly entitled to no weight. This is crazy. I acknowledge that by citing my medical condition as a context for my conduct at the February 24th deposition, I have placed the narrow question. You don't get to determine the scope of this question. The narrow question of medical effects on that date at issue. What I have not placed at issue, and what no rule of procedure authorizes, is the specific nature of my surgical procedures, the intimate details of my medical care, or the fabrication of a carnival narrative built on the incidental fact that a prepaid cruise included a stop in Trinidad. But that was the theme of the cruise. That was the theme of the cruise. Do you think they did no celebrations on the cruise at all? We're going to go to Carnival in Trinidad and Tobago, but we're going to do nothing until the cruise ship actually ports. The legitimate scope of inquiry is limited to the narrow question of whether prescribed medication affected my cognition on February 24th, 2026. No, and also March 6th, because you used it as an excuse for March 6th as well. Speculation about surgical details and fabricated personal narratives fall entirely outside that scope, and we cite here Bray v. Purple Eagle Entertainment, distinguishing between personal information legitimately connected to the issues in dispute and personal attacks that are amorphous, unspecified, cannot be defended against, and could harm the defendant in the public eye. My portion of the Caribbean cruise reference... So, what? My portion of the Caribbean cruise. So is he separating himself from what the Caribbean cruise actually was? He has his own, I know this is the theme they advertise to everybody else, but my portion's different. When I booked it, I didn't have a medical emergency. But I booked this cruise. But now that I conveniently need to counter Fat Joe's claims against my misrepresentations to the court, I've got to distance myself from what the theme of this cruise was. That's how I read this. My portion of the Caribbean cruise. He has a timeshare. What is going on? Reference in plaintiff's papers was booked and fully paid for in or around the first quarter of 2025, nearly 1 year before my January 23rd, 2026 procedure, and nearly 1 year before the depositions at issue in this case. Which, this is such a catch-22 for him because he's so busy he can go on this cruise at all, but yet on February 3rd through 5th, he didn't even have the time to, or wherewithal, to send notice to the court that he wasn't going to appear for the court-ordered depositions on February 6th and February 9th. You knew about all of this in advance, and yet you just ghosted the court. The cruise was a passenger itinerary. It did not require physical exertion, athletic activity, or any participation incompatible with post-surgical recovery. A passenger on a scheduled cruise, confined largely to a ship's accommodations, is not engaged in the kind of strenuous activity plaintiff's papers imply. It was just like dancing, because of the theme of the festival. The relevant question is not whether I traveled, but whether the nature of the travel contradicts my account of my medical condition. It does not. I have booking confirmation and payment records establishing this timeline. This was a pre-existing personal commitment that I had made and paid for well before any of the events giving rise to the sanctions motion now before the court. It was not a spontaneous vacation taken in response to litigation pressure, and it was not cancelable without full forfeiture of the funds I'd paid. The cruise itinerary included a stop in Trinidad. This is a lot. We're getting into a lot here. Plaintiff's papers assert or imply that I was partying at the Trinidad Carnival. This allegation is not only false, it is physically impossible. I had undergone a surgical procedure on January 23rd, 2026, followed by a second procedure on February 3rd, 2026. I was in post-surgical recovery and on prescribed pain management medication during the period in question. A person 21 days removed from a second surgical procedure, actively recovering and taking narcotic medication prescribed by a physician, is not physically capable of participating in a carnival, especially Trinidad Carnival. The suggestion that I did so is not a mischaracterization. It is medically and physically absurd. The allegation was never supported by any evidence because no evidence exists. It was manufactured whole cloth and inserted into... I think Fat Joe's team has some pictures because they asked him questions about standing with a group and holding a cup. And that's you there holding a drink. And he's like, it's not alcohol, was his response in this deposition. So he's out and socializing. He's not just like going on this cruise and sitting in a cabin because he already paid for it, but can't move. It was manufactured whole cloth and inserted in federal court papers for the purpose of generating tabloid coverage, not for any purpose cognizable under the Federal Rules of Civil Procedure. The fact that the cruise itinerary included Trinidad does not place me at the Trinidad Carnival. Plaintiff's counsel conflated the existence of a prepaid cruise, booked a year in advance, documented, and paid for long before any deposition in this case, with a fabricated narrative of a recovering post-surgical attorney partying at a carnival. That conflation is not a good faith argument. It is an attempt to construct a false and humiliating image of me for an audience that has nothing to do with this litigation. And this is where we go. Again, his declarations go from like, I was in post-surgical recovery. This is me making a representation of something that would be my personal knowledge. And then we stray into, and he does this with all of his declarations, it seems, we stray into arguing, where we're no longer talking about personal knowledge of anything. We're arguing the arguments that should be in the motion. So we can argue it twice. That conflation is not a good faith argument. It's an attempt to construct a false and humiliating image of me for an audience that has nothing to do with this litigation. Okay, and the judge isn't concerned with me. I'm sure neither of these judges are concerned with us. Like, whatever Fat Joe happens to put in his motions, they make arguments as to why it's relevant. Their whole stance is that Terrence Dixon and Tyrone Blackburn are making any excuse to put off having to be properly deposed. Like, This is crazy. Adventure Aaron in the chat says issue summary. So that Target, the Minnesota case. Target settles slip and fall incident with Minnesota. Minnesota dismisses claims. Minnesota later... Oh, it's a person named Min. Never mind. Person named Min. Min later says she felt pressured to settle and did not understand the settlement terms due to pain meds and language barriers. Court decides that the settlement could not be enforced without sufficient evidence to demonstrate that both parties freely negotiated and assented to the terms of the settlement. This does not support Blackburn's claim, as there is no negotiation or agreement required before requesting sanctions from the court. It seems like this is even worse of a stretch than my first thought. My first thought was, a claim that somebody, like, hey, they denied my workers' comp claim saying that I was impaired for a reason I shouldn't have been at work, but that's not the case and they didn't prove it. That's what I expected because it seemed like that was kind of relevant to the argument. This doesn't seem like it really has any bearing. Oh, man. Well, not surprised. Hey, everybody coming in. Good to see you guys. Good to see you guys. Kristen says Uncle Google must be his best friend. Hey, Trial TV. Free us. We are free. Good to see you. Good to see you. Can't wait to see you guys go live. I know you've uploaded videos. Hope you are doing well. We are free. We've got, let's see. Abdi in the building, like, why don't judges just take away his law licenses? I don't know. Like, sometimes I'll see a news article like, somebody referred to grievance committee or somebody license suspended. And it's like, failure to miss a deadline for one client. And I'm like, and it's not just Blackburn, but I think there's some attorneys that have done that repeatedly. And when I see those articles, I'm like, well, maybe nobody's like raised the issue. But when it comes to Blackburn and looking at all these motions, several attorneys have raised the issue and said, look, like, he's not filing responses on behalf of his client. He's not informing his client of certain things. He's using AI. He's not showing up for court-ordered depositions. He's making these representations that aren't true. And you should refer him to the grievance committee wherever we're located. And it never seems to get there. So I think it's weird. I definitely think it's weird. So, we've got, let's see, where were we? Hot mess somewhere. Plaintiff's papers make reference to motions or documents I filed in other unrelated cases. Oh, do we got to do it again?
So many cases, I don't know. I just can't it's like a lot of cases.
And suggest that these filings reflect some form of improper conduct. In the period following my procedures on January 23rd and February 3rd, and during my recovery, I continued to meet my obligations to other clients in courts. Did you? Do I need to pull up? We just looked at that, like, Burroughs v. Combs case, where the judge is, like, warning the plaintiff that your chosen counsel isn't responding to things on time, and that could adversely affect your claims. Because it's going to look like an issue of you actually prosecuting your claims. Like, he says, I continue to meet my obligations to other clients and courts. Several documents that were filed in other... And this is so crazy because this exact time period is when we have the contempt. So remember, February 3rd is when he emails Fat Joe's team saying, I'm not going to be there for the February 6th and 9th deposition. Sorry. I'll tell the court, though. I'll let the court know. And then he doesn't let the court know until after Fat Joe sends a letter letting the court know. So he just got held in contempt for that. We just read that. And for what it's worth, that contempt order was filed after this was filed. But he's arguing here to support he's replying to Fat Joe's opposition to his motion for sanctions. And he's using this, he's perverting this context. saying that he continued to meet my obligations to other clients and courts. So to me, this kind of seems like an admission that you're dropping the ball on Dixon, your client here in this case, who you're also representing in a cross complaint because Terrence Dixon countersued Fat Joe. So this seems like an admission that you know you're dropping the ball and not meeting your obligations to Terrence Dixon as far as this case. And I don't see how it helps you to argue I was meeting deadlines and all my other obligations in other cases when this whole time you've been trying to argue that you were down and out because of your procedures and medication. You can't argue both. It doesn't make sense. Because this is basically coming down to everything was fine except for the purpose of arguing for myself in this case. I'm going to say I couldn't do work for this case even though I could do it everywhere else. It's crazy. It's crazy. Several documents that were filed in other matters during the post-surgical period. We've got eras now. He's carving out eras for himself. So this is the post-surgical period. Had been drafted prior to my surgeries. Fair enough. And some, well, okay, he is addressing it in the next line, because I was going to say one of them he couldn't have had pre-drafted because it was response to a judge's decision to dismiss a case. In some instances, these were pre-surgery documents that required resubmission to satisfy procedural requirements in those cases, not new work product generated while I was recovering. So I think what he's trying to get at here is he had to amend a complaint and refile it after it was dismissed, and I think it was dismissed with prejudice. And he ends up refiling, asking that court for leave to file an amended complaint, and sends in the amended complaint, which you have to make some degree of amendments to correct whatever issue was the basis for it getting dismissed. So he had to do some work. It wasn't just like the document was sitting there. But the bigger portions of it could have been the same. But I think Fat Joe referenced that in one of his filings. Like, he says he couldn't do work, but then here he is doing work. The filing of documents in unrelated cases is not evidence of anything. It is routine practice. It's evidence that if you can meet your obligations to other cases, then what's your excuse here? Plaintiff's efforts, I'm going to lose my mind. Plaintiff's effort to use my litigation activity in other courts to draw inferences about my conduct or credibility in this case is an improper conflation of unrelated matters and is unsupported by any legal authority. Plaintiff may argue that my continued filing of documents in other cases during the recovery period contradicts my medication defense, relying on authority such as in Ray Manuel. That reliance is misplaced. The documents filed in other matters during my recovery were pre-drafted submissions requiring only ministerial resubmission, not complex new legal work requiring sustained real-time recall, judgment, and responsiveness under examination. And remember, this is the same time period he's claiming in another case. Do I still have that up? I guess I don't know exactly when this work was. We got to check these docket numbers. Because here he is, he's saying he's doing like 10 hours of research work to look up fabricated citations in a different case. Like, I don't know. Let's see. Where were we? Where was that case we just looked at? Oh, yeah, right here. He says there is a material difference between resubmitting a prepared filing and conducting a live deposition. Plaintiff conflates these two categories to manufacture a contradiction that does not exist. I'm pretty sure he sat... Didn't Cartagena's filings say that he did depositions in other cases? I think it was like 3 different depositions that he did in relation to at least one other case during this time at issue. Or maybe that's why he's narrowing it down. He just says he just calls it the period. It's just the post-surgical period. But yeah, I'm pretty sure Cartagena was like, he also did other depositions. It is apparent from the totality of plaintiff's papers and the personal attacks contained therein are not... Oh. It is apparent from the totality of plaintiff's papers that the personal attacks contained therein are not addressed to this court. So I think he's claiming here that is he saying that the attacks and improper behavior being alleged in the initial motion for sanctions by Fat Joe? What? I could read this like 3 different ways. But it seems like he's just trying to say that they're lodging attacks that aren't really an argument to the court that relate to a sanctions argument. Oh, they're addressed to an audience outside this proceeding. Here we go. This litigation has been accompanied by a sustained and coordinated, we're still calling it coordinated. A coordinated media campaign involving blogs, tabloids, and social media platforms that has published coverage derived from confidential discovery materials, in this case, in an apparent violation of this court's protective order of December 8th, 2025. So the last time we got together and did deposition transcript readings, we read a transcript that was marked confidential that Tyrone Blackburn filed onto the docket. So if you missed that, we did read a transcript that had a confidential marker on it, but Tyrone Blackburn uploaded it. Was that coordinated? Was that a violation of this court's protective order? My gosh, this is just the declaration. Plaintiff's counsel's decision to introduce inflammatory personal characterizations about my medical procedures, a prepaid cruise, the nature of my filings in other cases, and a fabricated Trinidad Carnival narrative appears calculated to provide additional fodder for that same media apparatus. The personal attacks in plaintiff's papers call directly for the exercise of this court's inherent authority. The legal standard for intervention requires only that the challenged conduct serve no proper purpose before the court and be motivated by an improper purpose such as harassment. Cited here, Bloom v. Schlegel. That standard is satisfied here. In Bloom, not reported. Okay. A district court within the Second Circuit found that personal attacks on opposing counsel that were spiteful and vindictive constituted bad faith conduct warranting the exercise of the court's inherent sanctioning power, finding that the improper purpose of harassing and intimidating opposing litigants motivated the attorney's conduct. The court made clear that the conduct is entirely without color and motivated by improper purpose. Justifies use of this court's inherent authority to sanction. The personal attacks in plaintiff's papers, speculating about the nature of my surgical procedures, fabricating a carnival narrative, and mining my private medical recovery for litigation ammunition are precisely the type of conduct that Bloom identifies as warranting the court's inherent power. They are entirely without color. They serve no legitimate argument. They are motivated solely by the improper purpose of the harassment. God, it's like, you can say anything. Courts in several of my cases, tell us, have immediately intervened during similar inappropriate inquiries into my health. Oh, so now we're gonna say this is what other judges have done. The Honorable Leo Gordon in Gardner v. Combs, the Honorable James B. Clark, Cortez v. Colony Tire, have each in their respective courts terminated lines of inquiry by opposing counsel that were less invasive than what plaintiff's papers contain here, upon finding that such inquiries were designed to harass rather than to advance any legitimate litigation objective. Except you're a named defendant. You and your law firm are a named defendant here, and you were being deposed. I don't think that this is comparable at all, even if we take this at face value. This isn't comparable at all, because we're dealing with, opposing counsel. Hey, I'm going to stop that question. That's not relevant here. Let's keep the hearing going. I don't know the underlying circumstance. Versus a situation where we're dealing with depositions and Tyrone Blackburn himself is the deponent. So upon finding that such inquiries were designed to harass rather than to advance any legitimate litigation objective, in both instances, the court shut down the inquiries before the first sentence was complete. It sounds like this happened during a hearing, not a deposition, because unless you have the court babysitting your depositions in that case, this isn't comparable. Yeah, he either is or was Little Rod's lawyer. So, because I see YSL Kell saying I think he was. I don't know if there's been a change, but the initial lawsuit, the complaint was filed with Tyrone Blackburn as counsel. This is crazy. It's not comparable to a deposition, where you're a deponent. The standard for intervention is not whether the attack is the most offensive one imaginable. It is whether the attack serves any proper purpose before the court. Well, yeah, because you're claiming that you couldn't answer questions during a deposition. Even though you were sharp enough in the mind to have this sparring back and forth where you're saying that opposing counsel, Chad Siegel, you're asking him, you're not my husband, when's your transition date? And then the following deposition, you pretending not to remember any of that, but you're going, oh, I thought he already transitioned. It's very relative and related to your excuse for that conduct. And the party has the right to depose defendants in their case. So if plaintiffs need to argue that, hey, court, we need to do these depositions again because here's what happened at the first one. Here's Judge Rochon. We had to call her up during the hearing and say this is what was happening. And she granted our request to continue the deposition on another day because of what was happening, because of Tyrone Blackburn's behavior. It's extremely relevant. This is crazy. Plaintiff's medical procedure, speculation, and fabricated carnival narrative do not meet that standard. They have never met that standard. Plaintiff's counsel has operated without judicial check on this conduct, and it has continued to escalate as a result. And this is just reminding me of the "why are you yelling at me?" that he cited in his cross motion for sanctions, and then Joe Tacopina provided the transcript and the video. I'm like, I'm not yelling at you. There's a camera right there. Like, yeah, you are. You're leaning across the desk. Your fingers are in my face. There's a video. So, I have rejected countless media requests for response to these baseless attacks. I have denied television appearances and documentary interview requests. Yeah, because you would look stupid if you did them. You're not denying them out of the I don't talk to courts. Because you've done interviews talking about your cases, but this is embarrassing for you. So your reason likely for rejecting these is because it's not going to make you look better. I respectfully urge this court to exercise its inherent authority under Bloom and its authority under Rule 11 to strike or disregard all references in plaintiff's papers to the speculative nature of my medical procedures and to the fabricated Trinidad Carnival allegation, and to make clear on the record that such conduct will not be tolerated in proceedings before this court. I declare under penalty of perjury under the laws of the United States of America that the foregoing is true and correct to the best of my knowledge and belief. Respectfully submitted, Tyrone Blackburn. So actually, he has it dated down here. It says April 22nd in type. But the stamp from the court, from the ECF system, is 4/24. Because the deadline was the 22nd. Oh my gosh. I mean, I can understand a 1-day difference. But what is this? What is this? So then we have his actual argument. And I know it seems like we read his argument because that's what he does in his declarations. But we've got defendants Tyrone Blackburn and T.A. Blackburn Law, reply memorandum of law in further support of their cross motion for sanctions. Let's see. Preliminary statement. Plaintiff's opposition. Oh, sorry, let me cover in the screen here. Although, thank you, Fatima, for gracing us with your presence. We've got plaintiff's opposition to defendant's cross motion for sanctions does not disprove the cross motion's central premise. It sidesteps it. If you're motioning for sanctions, it's your burden, though. They don't really have to disprove. They can reply and oppose it. But it's not like it stands just because they don't sufficiently disprove it. Unless there's an order to show cause or something, but that's different. Defendants moved for sanctions because Joseph Takapina, as examining counsel, called Mr. Blackburn a clown on the record multiple times, threatened that Mr. Blackburn would not be around much longer in this business, falsely accused Mr. Blackburn of criminal conduct without any factual predicate established on the record. Oh my God. And he's really leaning that on the record might be doing some heavy lifting. Although I would disagree with that because he's represented in some of these like virtual conferences that I've listened in. In one of them, he talked about having to appear for this criminal case. And I would say that that puts the matter on the record. And again, that's still pending. Like the next date I see that is around the end of May. This is where he's facing charges for assault, recklessly causing physical injury, injury to a process server, reckless endangerment in the second, and leaving the scene of the accident, failure to show license or ID. So, oh my goodness. Lord. Let's see. And engage in a pattern of demeaning commentary designed to destabilize the examination rather than conduct it. That's what you did on February 24th. Plaintiff responds primarily by pointing to Mr. Blackburn's prior conduct at a different deposition. Yeah, the February 24th deposition. The Dixon. So we just read a whole motion where he's talking about how his post-surgical period isn't relevant. And we're not even through the first paragraph of the preliminary statement. And he himself is telling us exactly why skepticism towards his medical needs and his claims of his medical needs is highly relevant. Because that's going to be the excuse for him to counter this argument here. He's just in a circle going back and forth, creating his own catch-22. Plaintiff responds primarily by pointing to Mr. Blackburn's prior conduct at a different deposition, the February 24th, 2026 Dixon deposition, and arguing that a person who previously, quote, misbehaved, it's in quotes, cannot complain about the misconduct of opposing counsel. That is not the law, and it is not a defense. Plaintiff also argues that the video of the March 27th, 2026 deposition contradicts Mr. Blackburn's account of the proceedings. Yeah, they did the side-by-side table. Plaintiff has submitted a brief 2-minute clip. And again, chat, why did he submit a 2-minute clip? For the claims of the yelling, you're leaning across the table, you're pointing in my face. Why did we need a 2-minute clip? Because that would be a video. That would be a video addressing the words that Tyrone Blackburn wanted to represent just as words without any visual context to claim that Takapina was yelling, was leaning in, was being aggressive, and pointing in his face at the deposition. It's a very good reason to attach a brief 2-minute clip. But Tyrone Blackburn's going to argue that that was, some type of deceptive omission, just to only include 2 minutes. He says the full deposition transcript, however, speaks for itself. Yeah, it does, and I don't think it speaks in the way you think it does. He gets me going. He grates my gears. And confirms a sustained pattern of contemptuous, demeaning, and threatening language directed at Mr. Blackburn throughout that proceeding. Mr. Takapina's own admission on the record, I am yelling, yeah, cannot be reconstructed as sarcasm after the fact. It sounds exactly like sarcasm to me. Put a 1 in the chat if you think it's, or comments if you're on replay crew. A 1 in the chat for sarcasm in response to Tyrone Blackburn. Put a 2 in the chat if you think Joe Takapina was aggressively yelling in this contemptuous, demeaning, and threatening manner. 1 for Takapina was sarcastically responding. 2, it was contemptuous, demeaning, and threatening language. And Blackburn argues that it cannot be reconstructed as sarcasm after the fact. Plaintiff's reply further mischaracterizes case law, invents procedural postures from cited decisions. So he's claiming of inventing postures from the citations, imports inapplicable statutory standards, and offers a dismissive treatment of the protective order violation that his own brief previously identified as the most serious discovery violation in this case. Each of those failures is addressed below. The cross motion should be granted. Now, if you missed this, the Jordan Siev reply or response in opposition, he responded, he attached several email exchanges and cited those. He made several references to these email exchanges showing that Fat Joe's team went through the procedure to say, hey, we're de-designated these portions. And then they only filed those portions on the record. Everything else is filed under seal. So, I can't go and pull it from the docket. This is the same stuff that Tyrone Blackburn was saying he couldn't access, but that the public had access to in full. And that's not true. There's 3 things wrong with that characterization. But Jordan Siev, in his opposition to the cross motion for sanctions, laid this out, that they followed the procedure according to the court's protective order. Let's see if we get that specific argument addressed, or if we're just going to have this blanket claim that Fat Joe's team failed to follow the protective order. So now we have argument. Lots of 1s in the chat. Yeah, I'm with that adventure, Aaron. We can submit the whole video deposition if you want, Mr. Blackburn, no problem. And if that's the case, right, I guarantee we'll have a complaint later. Oh, this is fodder for the media. But you're goading the idea of releasing the whole video. You're claiming that it would look good for you. And you're claiming that the only reason opposing counsel didn't submit the whole thing is because it looks bad for them. So you're goading the release of the whole thing. And I'd actually kind of like it because the transcript that he attached, again, it seemed like the second half of it wasn't fully prepared and fixed up by the court reporter, the transcriptionist that was present. Because it got kind of phonetic and weird at the end. It was a bit difficult to read. So a video would cure that. So it'd be interesting. Yeah, we should do a cogs emoji. It gets me going, grinds my gear. That's a good one. Let's see. The sole question remaining is whether these acts... Oh, wait, did I miss something? Okay, so the argument's repeating. Okay. Plaintiff's opposition does not deny that Mr. Takapina called Mr. Blackburn a clown on the record, told Mr. Blackburn he would not be around much longer in this business, referenced Mr. Blackburn's pending criminal indictment, not as a question but as a rhetorical weapon, and stated on the record, I am yelling, yeah, I'm yelling. Plaintiff confirms all of this. These are admissions of every key fact underlying the cross motion. The sole question remaining is whether those acts constitute conduct that Rule 30D is designed to deter. The answer is yes. Rule 30D2 empowers courts to impose sanctions on a person who impedes, delays, or frustrates the fair examination of the deponent. The rule's text is not limited to conduct that physically prevents testimony. Courts in this circuit have consistently held that conduct rendering a deposition abusive, harassing, or coercive falls squarely within its reach. We've got a holding here from Ciccarelli v. Genentron. The decision to impose sanctions against an attorney for improper conduct during a deposition is within the discretion of the court. And Chala v. Metro Oral Surgery. Sanctioning attorney whose conduct impeded, delayed, and frustrated the deposition. Plaintiff's failure to contest these core facts operates as a concession that each event occurred. We have Coker v. Goldberg saying defendants are deemed to have conceded these arguments by failing to address them in their opposition brief. I think he did address them. Because we had that side-by-side comparison table. Notably, plaintiff's own brief cites Coker for this exact proposition, then fails to apply it to the very concessions plaintiff himself made by not contesting the factual predicate of the cross motion. Then we've got plaintiff mischaracterizes the case law supporting his opposition. Now let's strap in for this one because we are getting claims that plaintiff's parenthetical description of the case, Callaway v. Marvel Entertainment Group, is fabricated. Plaintiff cites Callaway v. Marvel Entertainment. This seems to be like his new thing, just accuse opposing counsel of fabricating citations. He cites Callaway with a parenthetical asserting that the court appointed a special master where ... ellipses, where counsel for the deponent obstructed the initial deposition. That is not what the case says. The decision reflects that a special master was requested and appointed against a backdrop for a long series of discovery disputes, but contains no finding, holding, or statement that counsel obstructed the initial deposition. Plaintiff invented that parenthetical. The court should disregard the citation to the extent it rests on a procedural posture that does not exist in the cited text. Then we've got plaintiff's parenthetical description of EEOC v. Local 580 overstates the holding that plaintiff cites. For the proposition that a special master was appointed where defendants had a history of failing to comply with court orders and the court found defendants' claim of impecuniousness unconvincing. The quote does appear in the case, but in a specific and narrow context. The court rejected defendants' cost objection because they had spent 9 years blatantly ignoring a consent judgment before raising ability to pay as a concern. That fact-specific rejection of a cost objection in a decade-long contempt proceeding does not stand for the general proposition that impecuniousness claims are inherently unconvincing in all cases, and plaintiff's parenthetical implies precisely that broader principle. Plaintiff's paraphrase inflates the authority beyond its actual scope. So then we've got plaintiff imports requirement from the prison. Well, what was it? Yeah, because the request was just to appoint a special master for a failure of complying with court orders. So while the failure to comply might not specifically be a 10-year failure, Jordan Siev, Joe Takapina, Ian Terrell, like they've provided a failure of Tyrone Blackburn to comply with court orders in this very case, as well as cited unrelated, according to Blackburn, that shouldn't have any bearing on this evidentiary record. Unrelated cases that Tyrone Blackburn also has, where he has these failures to comply with court orders. So Blackburn, at least in the declaration, was making the argument that, oh, they're bringing up these other cases that are relevant, they shouldn't be considered. This is, again, why they're relevant. If you're going to make an argument like this necessarily shows why it's necessary and fair game for Fat Joe's team to include these other cases in their filing. In addition to that, since the opposition was filed to Tyrone Blackburn's motion for cross sanctions, we've seen that this court has decided to hold Tyrone Blackburn in contempt for failing to abide by this court's orders. Look at that. And then we also saw the warning in the Burroughs v. Combs case where Judge Mary V was like, plaintiff, your chosen counsel is missing deadlines. Gotta be careful. What's going on? So not only is it relevant, but there's the existence of a paper trail of this. So, like, this is crazy. So he's saying it doesn't, the scope is different. Then we have plaintiff imports requirements from the Prisoner Litigation Reform Act that have no application here. Plaintiff argues that a special master must be narrowly drawn, extends no further than necessary to correct the violation of the federal right, and is the least intrusive means necessary. That standard is drawn from 18 U.S.C. 3626A1A. I think, if I'm not mistaken, I feel like this is the case that Fat Joe cited in the opposition. based on something that Tyrone Blackburn brought up in his opposition to Fat Joe's motion for sanctions and his motion for cross sanctions. And Fat Joe's is like, this is actually what this case says. But I don't think it was the first time that this case was prompted. Like, there was a reason that this case was brought up in the opposition to the cross motion. Anyway, it goes on. It says the standards drawn from 18 U.S.C. section 3626A1A, the Prisoner Litigation Reform Act, we're going to call that PLRA, which governs remedies exclusively in prison conditions litigation. See Hires v. Marticello. The PLRA's least intrusive means requirement was enacted specifically for prisoner cases. No court has applied that standard to Federal Rules of Civil Procedure 53 in a non-prisoner case, and plaintiff has not cited one. The court should reject his attempt to graft an inapplicable statutory restriction onto Rule 53. Next argument's about the video. Here we go, guys. The video record does not exonerate Mr. Tacopina. Plaintiff submitted a 2-minute clip. Submit the whole thing. Plaintiff submitted a 2-minute clip from the March 27th, 2026 deposition covering approximately 1 minute and 1:06 p.m. to 1:08 p.m. of a full day proceeding. This sounds like an argument to release the whole thing. And since Tyrone Blackburn's the one that provided the confidential transcript, could he really oppose the whole thing coming out? That excerpt does not capture the clown remark. It does not capture the career threat. Release the thing. It does not capture the indictment reference. It does not capture the self-admitted yelling. Every one of those events is documented in the full written transcript, which plaintiff submitted in its entirety and cites throughout his brief. What? He's saying plaintiff submitted it? For March 27th? What? Is he lost? This is filed by Tyrone Blackburn. This is, again, the confidential marking. This is the 298-page full transcript. Uploaded by Tyrone Blackburn. He's saying plaintiff submitted in its entirety and cites throughout his brief. Is he getting confused? The written transcript is the complete and authoritative record of the March 27th deposition. It shows without ambiguity that Mr. Tacopina stated, "You're a clown. Does that?" And when asked whether he had just called Mr. Blackburn a clown, responded, "I did. I called you a clown because you are." It shows Mr. Tacopina stating, "I know you're not going to be around much longer in this business." It shows Mr. Tacopina saying, "I am yelling, yeah." A 2-minute clip from 1 minute in a full day proceeding does not erase, contextualize, or neutralize these statements. Release the whole thing. Mr. Blackburn has personal first-hand knowledge of how Mr. Tacopina spoke to him throughout the entirety of the March 27th deposition. The submitted clip, whether by reason of selective editing, compression, or otherwise, does not accurately reflect the tenor, volume, and way Mr. Tacopina conducted himself throughout that proceeding. Release the whole video. This seems like a concession that you agree that Tacopina's demeanor, which would include the accusation of aggressively leaning that you previously argued in your motion for cross sanctions, is not present in this clip. But yet that clip is where you're accusing him of presently, contemporaneously leaning in aggressively. So if that demeanor is absent, and you're conceding that it's absent in this clip, but this is the clip where you claim contemporaneously it's happening, what does that mean? It means you were lying when you made that claim on the record. Probably with the hope that you could rely, after hours of this deposition had gone by, you can prompt some kind of response that will look bad on paper from Tacopina, and you can reference yourself on the record claiming it's something that it wasn't. This is the same individual who in his opposition to the plaintiff's motion for sanctions, I apologize at the very next deposition on the record. Which to me just suggests that that Tyrone Blackburn sees his deposition, this March 27th deposition, as an opportunity to go in there and know what he needs to put on the record. Which would go with this. And this deposition was 3 days after plaintiff filed their motion for sanctions. So he already knew going into this deposition, hey, I might want to come up with some fodder to boomerang their motion for sanctions back on them. On the record. Under oath. It's slick. It's not convincing to me. It's slick. Accordingly, defendants respectfully request that the court direct plaintiff to produce the complete, unedited, native format video recording. There we go! Let's go! Let's go, chat! He wants the court to order Joe Tacopina to release the whole thing. Let's get together. Let's get together and have a good time. He wants the complete unedited video recording of the March 27th, 2026 deposition with all metadata intact, in sufficient time for the court's review prior to the May 18th oral argument. The court should evaluate this cross motion on the full record, not a curated excerpt. My goodness. These chats are like giant and circular today. I usually use these. Hi, Nick. I'm glad that you're glad to be back. I'm so glad to be back. I wanted to go live so badly and look at Tyrone Blackburn this weekend. Not look at him, but, look at this mess. So, yeah, let's get this whole video deposition released. Let's go. We've got Mr. Tacopina's remarks were not justified by Mr. Blackburn's prior conduct at a different proceeding. Plaintiff's primary defense is that Mr. Tacopina's conduct was a proportionate response to Mr. Blackburn's prior misconduct at the February 24th and March 6th depositions. That argument fails for 3 independent reasons. Oh, here we go. Prior misconduct by one party's counsel does not license opposing counsel to respond with threats, slurs, or personal attacks at a later proceeding. What? I think the slurs came from Blackburn. The law does not permit tit-for-tat abuse. Whatever Mr. Blackburn may have said or done at a prior deposition, that history does not entitle Mr. Tacopina to call him a clown, threaten his career, or announce to the record that he is yelling. Counsel's... What? Is this like a trip up? Because again, this is Tyrone Blackburn writing, characterizing Tacopina. It says that history does not entitle Tacopina to call Tyrone Blackburn a clown, to threaten his career, or announce to the record that he is yelling. Who's doing all the announcing about yelling? Did we write this ourselves? To be fair, it could go either way. Counsel's conduct at each proceeding is measured against an objective standard of professional behavior, not against the conduct of opposing counsel at a separate event. And so they're stating, this is the Warhol case. We have Schleifer and Nance. So were they going at it in this case? That's hilarious. This is Schleifer, Nance, and co. versus the estate of Warhol. I think this was that trademark with the photography. And then see also Ramos v. Sears and Kmart. Dang, I forgot about Kmart. Imposing sanctions for attorneys' repeated yelling at opposing counsel during deposition, notwithstanding the opposing party's own conduct. Moreover, plaintiff's own argument concedes that the conduct at issue occurred at the March 27th deposition, not the earlier proceedings. At the March 27th deposition, Mr. Blackburn appeared without any medication issue, was fully compliant with the examination, apologized sincerely to Mr. Siegel for his earlier conduct. Over a month later, and attempted in good faith to answer questions. It was in this context, a cooperative deponent at a rescheduled proceeding, that Mr. Tacopina chose to escalate rather than de-escalate. That escalation is not justified by events at prior proceedings at which Mr. Tacopina was not even examining counsel. Yeah, I'm pretty sure by the time we got to the part of the transcript where we got to this clown comment, it was after Tyrone Blackburn had kept pretending, oh, I can't see what's on the screen. You didn't tell me the exhibit number. Court reporter, can you read that back? Oh, sorry, I didn't hear you say the exhibit number, but you did. It was like after 100 and something pages of that had gone on. So I disagree that there wasn't justification for opposing counsel to be frustrated or noting things for the record. If plaintiff's counsel wished to raise Mr. Blackburn's prior conduct, the appropriate vehicle was a motion or letter to the court, not a personal attack on the record during a deposition. Using a deposition as a forum to litigate perceived grievances about an opposing attorney's professional history, while calling that attorney names and threatening his career, is precisely what Rule 30D prohibits. And we cannot lose the context of this. This is not a deposition where, let's say, I'm an attorney, I have my client that I'm representing, and I'm deposing Adventure Aaron's attorney. This is not a situation where the deponent, the person who's being deposed, is sitting there, and I'm just sitting there disparaging opposing counsel who's there with their client. This is Joe Tacopina, an attorney, deposing a defendant in this case who happens to be an attorney, who's also there on behalf of his law firm, who's also a defendant in this case, regarding conduct about potential extortion and defamatory statements made by Tyrone Blackburn. So, like, there's a bit more layer here. So the idea of asking questions about attorney conduct and behavior, is the only purpose of that purely for Tacopina to harass and or threaten Tyrone Blackburn? Or might these questions go to the nature of the claims? Oh my goodness. Really gets my gears going, you guys. If plaintiff's counsel wished to raise Mr. Blackburn's prior conduct, the appropriate vehicle would have been a motion or letter to the court, not using this as a forum to litigate perceived grievances. This isn't about perceived grievances. This is about the claims of the complaint. Next, we have Mr. Tacopina's indictment statement. Constitutes independent sanctionable conduct. So this is you're under indictment. Plaintiff responds to the cross motion's objection to Mr. Tacopina's statement, "You're under indicted for running over our process server," by noting that Mr. Blackburn is, in fact, under indictment. Well, that's interesting because in your cross motion, you kept arguing that that might not be the case. And I think you said in the transcript that that wasn't the case. Or played dumb to the extent that there's no excuse for. The accuracy of the underlying fact. So now we finally say, in a distanced way, that it is accurate, in fact. Does not resolve the question raised by the cross motion. Mr. Tacopina did not ask Mr. Blackburn about the indictment. He did not seek testimony about it. He announced it in the same breath as calling Mr. Blackburn a clown, and threatened his professional career as a means of belittling the witness during sworn examination. Truth is a defense to defamation. It is not a license to weaponize opponents' pending criminal matter mid-examination for purposes of intimidation. Let's see. He cites here Leon V. Anderson's Tree Service, evaluating sanctions against counsel for raising personal matters about opposing counsel during deposition for purposes of harassment rather than legitimate examination. The cross motion does not allege the statement was false. It alleges that the manner and purpose of its use constituted harassment. Plaintiff has not addressed that argument, and his silence constitutes a concession. This isn't how I walked away from the opposition from Jordan Siev. I think we moved the goalpost significantly here. Mr. Blackburn's apology was genuine, timely, and legally significant. Plaintiff contends that Mr. Blackburn's apology at the March 27, 2026 deposition was too little too late, and constitutes mere damage control. It was a month later, and in the middle of it's not like you got to the deposition and said, before we start, I'm so sorry, Chad Siegel, that I said those things. I wasn't myself. That's not how it went. Plaintiff relies principally on in re Sobolewski. That reliance is misplaced. In Sobolewski, the sanctioned attorney exhibited a years-long pattern of neglect across multiple client matters. Submitted inadequate briefs in case after case. Failed to appear before the disciplinary committee. I write that one, we don't check that one yet. And offered his 1,000 apologies only at the close of a disciplinary proceeding, documenting sustained systemic misconduct across many clients over many years. Yeah, maybe like waiting until the middle or end of a long deposition. The Second Circuit found that his apologies gave the committee little confidence that he appreciates the significance of his conduct because of Sobolewski's overall response to the proceedings and his reluctance to even appear before the disciplinary committee. That is not this case. At the March 27th, he's putting the dates. He says at the March 27th deposition, the first full deposition. Oh, that's how we're going to move the goalposts on this one, guys. Now it's not the very first deposition. Now it's the first full deposition. Proceeding following the February 24th events, Mr. Blackburn appeared, answered questions cooperatively, and apologized directly to Mr. Siegel on the record. And when we got to that apology, it was very sarcastic sounding to me. Where was it? Can we search this transcript to find it? They say apologize. Oh yeah, this is it. So we're gonna revisit this live. This is his apology. He ran in there. It was not like this other case where this person who apologized at the end of a hearing didn't fully appreciate the issue with their own conduct. I am on PDF page 159 of this transcript. It's paper stamped as 181. Let's read this. Just listen to my question, man. No. This is also while he's saying he's answering questions cooperatively. We have Takapina saying, just listen to my question, man. No. Just look at my question. You're yelling again. I'm not yelling again. Listen to my question. See, now you're mocking me. You're being aggressive. Again, from the guy who told my partner that his mother should have spit him out instead of swallowed. Right. A mock transgender. I don't, and I believe that was probably the medication. Oh, okay. And if it was said, then, I apologize to your partner regarding that. It was not, you were on medication that day too? I was, like I said, I answered that question too. So hold on. He just claimed he was cooperative that day. And this is the little sample right here. He's not being cooperative. He said he apologized directly to Chad Siegel. He isn't. And he's saying that it's a genuine apology and different from this other case that wasn't seemingly a genuine apology. What kind of genuine apology starts with, and if it was said? So this little page and a half contradicts 3 of his characterizations of his own apology. Anyway. So that is not this case. At the March 27th deposition, the first full deposition proceeding following the February 24th events, Mr. Blackburn appeared, answered questions cooperatively, and apologized directly to Mr. Siegel on the record. No show cause order compelled that apology. Yeah, maybe the sanction for motions 3 days before prompted that apology. So you see how now he's narrowing. This is true. There was no show cause order, but that's not the complete argument. There's something else very significant, a motion for sanctions, that preceded this apology by 3 days. No court directive required it. It was voluntary, offered before any examination resumed. What? As a matter of professional acknowledgement. Is he going to say that this happened off the record? Because he said it's on the record, and it's not at the beginning of the transcript. Or is he lost again? Just like when he said that the plaintiff filed this transcript. I don't even know, guys. I don't even know. We'll have to see. We'll see what happens. Plaintiff also argues that the apology was deficient because Mr. Blackburn falsely blamed his medication. That's in quotes. Whether medication played a role in Mr. Blackburn's demeanor on March 6, 2026 is a disputed factual question that cannot be resolved by plaintiff's conclusory characterization. If it's disputed, you should have... He's saying here, he's prepared to produce at an evidentiary hearing the prescribed medication and pharmacy records confirming the name, dosage, and duration of his treatment regimen, the written prescription from his treating provider, booking and payment confirmation establishing that the Caribbean cruise was reserved and fully paid for the first quarter of 2025, nearly 1 year before the events at issue, as a pre-existing commitment that could not be canceled without forfeiture, and a declaration or certification from a qualified medical expert confirming the documented pharmacological effects of narcotics medications on individuals who do not consume alcohol, narcotics, or other mind-altering substances, including the episodic and context-dependent nature of cognitive impairment in opioid-naive patients. I've never heard that phrase before. Mr. Blackburn has nothing to conceal. He invites the court to evaluate his conduct against a complete and verified factual record, rather than against plaintiff's selective and misleading characterization of it. So this paragraph went off the rails a little bit here. What's interesting here is we are, again, sidestepping the issue about, he's like, you know, they're complaining that I went on a cruise to party, but I didn't. It was booked. I just didn't want to lose my deposit. That really isn't the complete issue as raised by Fat Joe. Fat Joe's issue was Tyrone Blackburn represented to the court he wasn't going to be like flying anywhere. He said something to the effect of, it's not like I'm going to be flying anywhere. It's not like I'm going to hop on a plane. And then because of the travel for the procedures in California, which were kind of like a narrow window that driving's probably not possible. And then also the cruise deporting out of Puerto Rico. They're like, well, when he's telling the court, it's not like I went on a plane or anything. It's not like I had to fly. That's not true. It's not honesty with the court. It's not him following his duty of candor to the court. And that might seem nitpicky, but if you tell the court something that's not true, even if it's like a very specific tiny thing, that's a problem. Plaintiff cannot escape the prejudice inquiry under Rule 30D. Plaintiff argues that the cross motion must fail because Mr. Blackburn has not demonstrated prejudice resulting from Mr. Tacopina's conduct. But prejudice was demonstrated in the cross motion itself, and the full transcript confirms it. Just give us the video. Mr. Tacopina's sustained pattern of demeaning commentary, calling Mr. Blackburn a clown, threatening his career, invoking his criminal indictment as a taunt. Is this a sustained pattern? And self-admittedly yelling. Disrupted the flow of examination, required Mr. Blackburn to repeatedly request that questioning be conducted professionally, and created a coercive atmosphere that no rule of civil procedure sanctions. Courts in the circuit have found prejudice under Rule 30D, where counsel's pervasive interruptions and personal attacks disrupted examination and corrupted the voluntariness of the record. They cite here Fashion Exchange, LLC v. Hybrid Promotions, imposing sanctions where obstructive deposition conduct disrupted opposing parties' ability to obtain testimony. Plaintiff's reliance on Town Square Media Inc. versus Regency Furniture is misplaced. In that case, the court found no prejudice because the challenged testimony did not hinder defendants in any material way. Here, the examination was repeatedly interrupted by exchanges about whether Mr. Tacopina was yelling. Who started those exchanges? And whether his conduct warranted calling the court. Disruptions caused not by Mr. Blackburn, but by Mr. Tacopina's own escalating conduct. Who made these claims? Oh my God. The prejudice to the orderly administration of the deposition is apparent from the transcript itself. Plaintiff's protection order violation cannot be dismissed with a footnote. Plaintiff's own opposition brief described the publication of confidential deposition transcripts and videos as the most serious discovery violation in this case. His reply now attempts to reduce that violation to a single paragraph, characterizing it as a proper de-designation because a close of business Friday email was sent to Mr. Blackburn requesting objections by end of day, to which Mr. Blackburn did not respond within that compressed window. That argument fails for 3 reasons. The protective order entered by this court on December 8, 2025, does not authorize unilateral de-designation by close of business letter. It requires a process. A party seeking to de-designate confidential materials bears the burden of demonstrating the appropriateness of removal, not of demanding that the opposing party object within hours of forfeit protection entirely. Yeah, is he going to give us any dates? I mean, why not show the timings? A party seeking to de-designate confidential material bears the burden of demonstrating the appropriateness of removal, not of demanding that the opposing party object within hours or forfeit protection entirely. Proper notice and opportunity to respond are essential elements when considering alleged violations of confidentiality orders. He didn't even attempt to de-designate the transcript that he uploaded. At least he's provided no record establishing such. The media reports plaintiff... Oh no. Here we go. The media reports plaintiff relies upon explicitly state that journalists relied on legal documents reviewed by Complex. Language suggesting prior access to the materials rather than same-day discovery of freshly de-designated public filings. No, it doesn't suggest that. How does legal documents reviewed by Complex, that phrase in quotes, suggest prior access to the materials and not same-day discovery? Oh my God. Plaintiff has offered no evidence that the media obtained the content only after the March 24th, 2026 public filing. That's not his burden. You're the one making the claim that there's a coordinated media effort. I'm going to lose it. As opposed to before it. That evidentiary gap undermines the entire chronological foundation of his de-designation defense. What? This court's March 30th, 2026 order further confirms that the discovery materials at issue were not presumptively public judicial documents, as they were produced for party review rather than for use in the judicial function. If that is so, the protective order's force remained intact regardless of the de-designation letter, and plaintiff's publications to the media could not have been authorized by a procedure that failed to comply with the order's requirements. So he's still representing this all through and through as some type of handoff to the media. Defendants have filed a separate motion requesting an evidentiary hearing at which plaintiff's counsel will be required to produce all communications with media representatives concerning these disclosures and to testify under oath about the sequence and circumstances of the publications. I didn't see this. Right? That would have been... It would have had to have been after March 24th because that's when the alleged improper de-designation would have occurred. There was a lot on March 24th. So, and again, that reminded me of something else. There's been no request by Tyrone Blackburn. Still, we're almost done with the motion. Maybe it'll pop up in the motion. But there's been no request. Can you strike these de-designated things that were improperly de-designated from the record? It's prejudicing my client. We don't want it out there. It shouldn't be up there. I still didn't see a request to take it off the public record. So where do we have this request for a hearing? Because maybe I missed that. Maybe I just didn't think... Unless he means, like, he requested it as relief in his opposition. Yeah, I don't see any result for the word hearing in this motion for cross sanctions. And I don't see a separate filing. The stuff's all filed by Fat Joe's team. Jordan Siev, an order. Jordan Siev, order, an order, a letter from Jordan. This is from a different party in the cross complaint. Let's see. There's a scheduling. Another party in the cross complaint. There's nothing. Maybe this will be the one. No result for hearing. This is one we just looked at. And then again, these are just oral arguments for the sanctions, not the issue he's talking about. And then this is the stuff we're reading today. So what is he talking about? Defendants have filed a separate motion requesting an evidentiary hearing at which plaintiff's counsel will be required to produce all communications with media representatives concerning these disclosures and to testify under oath about the sequence and circumstances of the publication. So they're requesting a hearing at which, presuming that the plaintiff's counsel will be required. As if the court's already requiring this of plaintiffs. This is weird. And where is it? I mean, this is from the 23rd. Because sometimes this might file first, but then like the other documents come in late because of however they get filed and uploaded. Just don't see it. Ooh, Adventure Aaron says this is a ploy to reopen the discovery window. That seems on brand. That seems consistent. All right, we've only got one more paragraph, so let's see if we have this request. The cross motion is not frivolous and is not sanctionable. Plaintiff's reply suggests, without developing the argument, that the cross motion was filed in bad faith. That contention is meritless. The cross motion is grounded in direct quotations from a certified deposition transcript that plaintiff himself submitted. Plaintiff did not submit it! He said it twice! And this is a bit different than just missing placeholder words. This is that plaintiff himself. When you add something like himself, you're stressing the point of origin of who you're speaking about. So this is just incorrect. Tyrone Blackburn filed the March 27th deposition transcript that's marked confidential without any designation. Oh my gosh. And cites throughout his own papers. This mirrors language that Jordan Siev was using in the cross motion. I don't know. I have questions about who or what wrote this. Because it almost seems to be absorbing some words and phrases that were in the opposition to the cross motion for sanctions and getting confused on what party it applies to. Because this doesn't make sense being written by Tyrone Blackburn from his perspective here. The underlying facts, the clown remark, the career threat, the indictment reference, the self-admitted yelling are not in dispute. A motion grounded in undisputed on-the-record conduct cannot be characterized as frivolous. See Doe v. Martitucci. Rejecting sanctions where challenged statements were supported by evidence in the record. Plaintiff's bad faith argument, offered without legal authority and without engaging the record, is itself the kind of conclusory assertion that fails to carry any burden. And they cite Huber v. Marine Midland Bank. Conclusory statements are inadequate to carry this burden. Conclusion. For the foregoing reasons, defendants Tyrone Blackburn and T.A. Blackburn Law respectfully request that the court grant their cross motion for sanctions and issue findings that Mr. Takapina's conduct at the March 27, 2026 deposition violated Federal Rules of Civil Procedure 30D. 2. Impose such monetary or non-monetary sanctions as the court deems appropriate, including an award of attorney's fees and costs incurred in connection with the March 27, 2026 deposition and this cross motion. What? Direct plaintiff to produce the complete unedited native format video recording of, there we go, they want this relief. They say direct plaintiff to produce the complete unedited native format video recording of the March 27th, 2026 deposition with all metadata intact prior to the May 18th, 2026 oral argument for deny plaintiff's motion for sanctions for the reasons set forth in defendant's opposition brief. And 5, grant such other and further relief as the court deems just and proper. And again, this one's dated April 22nd in print, but it's stamped as the 23rd. This is the one that was stamped the 23rd. The other was stamped the 24th, but the text said the 22nd. Because the deadline, the court-ordered deadline for this reply was the 22nd. So, I know this happens, right? You might type something up, print it out, whatever, and then you don't actually submit it, but it was done, but technically it gets submitted the next day. But this is kind of a sketchy thing to do when you want everything else that you're arguing to be taken at face value. Respectfully submitted, Tyrone Blackburn. Ah, chat. Hey, Darth. Hey, Claire. Good to see you guys. I am so glad to be back. Thank you. It was a long 2 days, long 48 hours. It was a long 24 hours the first time. And then since I had a restriction again without any notice, I was like, what if it just doesn't come back? Like, I don't have any reason. I don't know why I'm gone. I already was restricted for 24 hours. Is this just going to be 24 hours? And when 24 hours passed for this second restriction and I still couldn't stream live, I thought I was toast. I thought I was just going to be stuck for who knows how long. I just had no idea. So it was a huge relief to see that we're back. We're so back. Guys, we got a little bit more. So remember, there's not supposed to be any further briefing. They're going to do this argument. It seems to be an in-person oral argument on this motion for sanctions in front of the new judge, Jennifer Willis. No more filings are supposed to be filed. This was supposed to be filed by the 22nd. The deadline was missed. But we do have a letter to the court addressing a narrow issue. And I have it open already. So this is Jordan Siev writing in to Judge Willis. Shortly after, it was, I saw it hit the docket. Actually, I can tell you the timestamps. I don't know if there's a delay between when I would get email notifications that there's something new on the docket. Let's see. But let's see, on Friday, I saw the alerts for the declaration by Blackburn at 9:07 in the morning. And then by 5 p.m., I got the notice for the letter. So they responded the same day. So we've got, Dear Judge Willis, we submit this letter to promptly draw the court's attention to false and malicious statements in defendant Tyrone Blackburn and T.A. Blackburn Law, collectively Blackburn, reply, filed last night. Okay, so I guess it went through last night. In further support of his motion for sanctions. The reply. We are mindful of your Honor's order limiting further briefing to Blackburn's reply. This letter does not address legal arguments, distinguish precedent, or argue substantive issues. So we're not violating your order. We're not like trying to go at these briefs back and forth. Its sole purpose is to address the false and malicious accusations of professional misconduct leveled against plaintiff's counsel in Blackburn's reply, which was filed 2 days after the court-imposed deadline. For the reasons discussed below, Mr. Cartagena respectfully requests that the court strike Mr. Blackburn's reply and order Blackburn to refile it, omitting his demonstrably false accusations against Mr. Cartagena's counsel. In his reply, Blackburn accuses Mr. Cartagena's counsel of fabricating and inventing case parentheticals. Blackburn states that Mr. Cartagena's counsel cited Callaway v. Marvel Entertainment Group, Exhibit 1, so they attached the case, with a parenthetical asserting that the court appointed a special master where, ... ellipses, counsel for the deponent obstructed the initial deposition. Blackburn argues that the decision contains no finding, holding, or statement that counsel obstructed the initial deposition, and that plaintiff's counsel invented that parenthetical. Blackburn's accusations are false. First, Mr. Cartagena's description of Callaway is accurate. In Callaway, Judge Robert Sweet states, are you ready for this, guys? This is talking about this Callaway v. Marvel case and what happened in a deposition in that matter. The judge says, the incident giving rise to the order to show took place at a deposition on August 14th, 1985, in the course of which Arnoff, an attorney for a third-party defendant, picked up an ashtray and threw it at Ray LaFleur, counsel for Callaway. So they're just chucking... First of all, this is 1985. There's like ashtrays during the depositions. And he's chucking this ashtray at counsel for the plaintiff in the case. An attorney throwing an ashtray at opposing counsel during a deposition is, by any reasonable measure, obstruction of the deposition. Thus, the parenthetical statement that ... the ellipses, counsel for the deponent obstructed the deposition, is accurate. Second, as the direct quotation Blackburn ascribes to Mr. Cartagena does not appear in Mr. Cartagena's brief. Let's think about that again, guys. We have, hey, we're writing to respond to the accusation of Mr. Cartagena's counsel fabricating and inventing parentheticals. And then we have the direct quotation Blackburn ascribes to Mr. Cartagena does not appear in Mr. Cartagena's brief. So Blackburn's using a direct quotation to make an argument while accusing someone else of fabricating quotations. It's a made-up quotation. Do you think we have a problem there? As the comparison below demonstrates, Blackburn inserted an ellipses and quotation marks around the phrase, counsel for the deponent obstructed the initial deposition, to falsely suggest that plaintiff's counsel presented this language as a direct quote from Callaway. So here we have a comparison table. Jordan, Mr. Siev is back with the comparison. Again, the header here, I love the headers. Blackburn's reply versus the actual text of Mr. Cartagena's combined opposition and reply brief. So Blackburn's reply states, plaintiff cites Callaway v. Marvel Entertainment Group with a parenthetical asserting that the court appointed a special master where ... counsel for the deponent obstructed the initial deposition. That's not what the case says. Callaway v. and this is the actual text of the brief. Callaway v. Marvel Entertainment Group, and then they give the citation here, appointing special master to supervise a continued deposition where a, quote, long series of discovery disputes, end quote, had, quote, arisen during the litigation, and, quote. The quote's over. The quotations are done. And then the text continues, and counsel for the deponent obstructed the initial deposition. In fact, Mr. Cartagena's parenthetical properly distinguished between quoted language, the long series of discovery disputes, and arisen during the litigation, and a descriptive parenthetical, that without quotes, counsel for the deponent obstructed the initial deposition. Therefore, as demonstrated, Mr. Cartagena's parenthetical was neither fabricated nor invented nor inaccurate in any way. Blackburn is attempting to impugn plaintiff's counsel's integrity by mischaracterizing not only Mr. Cartagena's brief, but also a publicly accessible court decision. Accusations that counsel fabricated or invented information submitted to the court carry significant weight, and such accusations should therefore not be made lightly, nor, certainly, falsely and maliciously, which is exactly what Blackburn did here. Accordingly, Mr. Cartagena respectfully requests that the court strike Blackburn's reply and order Blackburn to refile it, omitting his demonstrably false accusations against Mr. Cartagena's counsel. We thank the court for its attention to this matter. Respectfully submitted, Jordan Siev. So he's the table comparison guy. And then after that was filed, we started this stream off with the motion from Judge Rochon, who was still dealing with the motion for sanctions relating to the failure to appear of Dixon and Blackburn for the February 6th and 9th court-ordered depositions, where Rochon found the defendants to be held in contempt. So, now imagine you are Judge Willis, who's in receipt of all this. You've got to play catch-up. You're dealing with all of this. And now you already see another judge who's been very nice, very gracious, holding the same party in contempt. It's a hot mess. It's all a hot mess. That wraps us up. I think that's everything in relation to the Fat Joe case. For now. We'll see. If we get this video of the full March 27th deposition, even though we read the transcript, we're going to do a live. We're going to watch it. I really don't see why Fat Joe's team would oppose the release of the whole thing. So, I feel like Joe Tacopina would be happy to say upload it. So we'll see. And clearly I haven't been provided it early. Otherwise we would have watched it already. With that being said, guys, it's been great I was like, dang, all this stuff's popping off on the docket. I can't go live. So, yeah. Do we have a gaslighting emoji? We might need one. Adventure Aaron points out that Blackburn also stated that the cruise was for recovery. Yeah. He said it was for recovery. And not that it was a previously scheduled leave trip that could not be canceled without monetary loss, which is usually good cause for delay. Yeah. He said it was for recovery. And then I believe it was Cartagena's counsel that argued that it was booked in advance. Oh, actually, I think this is blurry. But I think Tyrone Blackburn, around the same time period where he represented to this court, it was for recovery. In another case, he mentioned that it was booked in advance. And so I think Cartagena's counsel pounced on that, because it's a conflicting representation to the court. Whether material to a claim of, you're able to do work for some clients, but somehow you're not able to meet deadlines in this case, I would say that that's a material argument, but even if it wasn't, there's still an issue with making these representations to one court and then another set of representations to a different court. So, Darth, I don't think there will be like stream access or anything. I don't know. When there's the virtual conferences, there's typically been a public access line, but it's usually included within the order saying like, hey, we're scheduling this virtual conference, and I didn't see any public access information for the May 18th. What I can do like the week leading up to it is if I don't see anything filed with the public access information, I will call the court and see if Judge Willis's court has a public access line that I can call and listen in. Now, I'm not supposed to like record or rebroadcast that, but I would at very least supply, if I see the call-in number, to you guys, so you guys can all listen in with me. We can be in the Discord chatting about it, all on listening while it's happening. But yeah, so I will be looking for that information, but it's not as, with Judge Rochon, this is a different judge, and it's also the first time that I think the meetings have been in person. So there's 2 reasons that it might be different than usual. But I'm going to try to find a way to listen in. So, yeah, Destin says, for now, we'll be back. EJF says, I've been in the bushes, currently trying to draft a response letter to my former landlord. Well, maybe resist the urge to call him a clown, to accuse him of yelling, because they'll whine and do it right back. I'm sorry you've got to deal with that. You know, I joke that my landlord is a little too DIY oriented. So sometimes he'll be here for quite a long time trying to fix things, which I do appreciate in some sense because he's not just, he'll fix an appliance rather than just throwing it into a landfill and swapping another junky appliance in. So I appreciate it, but sometimes it's awkward because I'll like not be able to stream because he'll be here for like 12 hours. So, but he's been probably the first landlord that I enjoy and appreciate and feel like is good communication with me, isn't out to ignore problems and then steal a security deposit. So I've been through tough situations with crappy landlords. I never wish that on anybody. And I think it's awesome that you are sticking up against it and fighting against it. Because I think they do hope that you won't. So I hope your Sunday gets more enjoyable. Or I hope the somewhat ability to commiserate with us reading these motions and what... I mean, imagine we're reading this because we're following what's going on in this case. But imagine you are the recipient. You are on the receiving end of having to deal with this. It's got to be frustrating. And Fat Joe is probably, I don't know what his finances look like. I know he still has shows and all that. But I think he's probably better situated financially, but that doesn't mean I'd wish him having to go through filing this defamation and extortion lawsuit because he's got parties sending him letters that if you don't give us this money, we'll go public with this. And once you do file, you're in this whole hot mess because those parties are trying to, in my opinion, avoid discovery for themselves. They want to open up and have a free pass to do discovery that they want to do, that they failed to do in a timely manner, but they don't want, as the defendants in this case, to have to be deposed or provide any requested materials in discovery. So I hope that was a bit of commiseration there on this fine Sunday. So, yeah, let's see. Oh, and good recommendation here, Adventure Aaron says, look for tenants' unions in the area. So they might have attorneys who could help and sometimes for free. And I appreciate that because I never would have thought of like the phrase tenant and union. But that gives a phrase for anybody to look and search for. Because sometimes the hardest part about like, I have a problem, what do I do to fix it? And the way you search, the way you word your own problem isn't going to get you to like a productive research on solutions. So good phrasing there from Adventure Aaron. Well, thank you guys for hanging out. Tomorrow we're going to do day 3 of the Julio Folio trial. In the morning before that, because I like the ability to skip the lunch breaks with these court hearings. There's also a SCOTUS case I want to look at tomorrow. It's Chattree v. US, or maybe it's like Shatree, I don't know. But it deals with, geofencing. Does it violate the 4th Amendment? And I think it might be an interesting oral argument to listen to. I think that's slated to start at 10 a.m. So if you guys are interested in watching that, please leave a comment. And you might see me pop up at 10 in the morning or whenever they start doing that first. And when those oral arguments end, I would fire up the Julio Folio stream. If not, we'll do Julio Folio starting at like 11-ish. Skip the breaks, and then we can do an evening re-listen of the SCOTUS oral arguments. And one of the reasons I prefer maybe waiting until the evening is because I can usually have closed captions through whatever we're replaying to hear the oral arguments, rather than enabling them through my own stream, which I, 1, forget to do, and 2, it delays the chat quite a bit. So, but yeah, we'll see. So, Vague and Ambiguous says it sounds interesting. Yeah, I think it's a important question. So, geofencing's popping up in more and more cases and investigations. I'm curious to see if it comes into play with like the investigation into the David case. It seems like there's going to be a lot of tech information, digital information, dealing with cell towers, where certain devices are, where the Tesla is. And I'm wondering if they use any geofencing to obtain information, and if we'll see arguments about that type of thing. But it's popping up in really any case where they're not sure who did something and they're looking to see what devices were in an area at a given point in time. But that ropes in anyone else who might have a device in that same area. And is it a privacy violation? for those individuals is what makes a search warrant sufficient and not overbroad when applying for a search warrant for some geofencing information. So, Stephanie, good to see you. I am back. Let's see. Oh, wait. What? Hold on, let me pull up. I'll link to this. Mary says, check out Cuffboy. They are saying one of the Julio 5 was trying to escape. Let's see. I think this is an older issue. I think this is something that happened a while ago, Sean Gathright, like before Alicia Andrews' trial, before we got into the weeds of waiting for this trial. I think it's an older issue that he's covering, but it's an interesting one. So I'm dropping the link to his upload in the description, and it's also going to be in the Creator Fronts playlist in the description of this video. If you're on Replay Crew and want to go check that out. If not, Cuff Boys, his channel, it's 1F, so it's like CUF Boys. So go subscribe to him. He covers a lot of great stuff. I love Cuff Boys stuff. But just wanted to make it clear that it's not a situation like over the weekend Sean Gathright tried to escape. It's dealing with like a matter from like a year back. So there we go. It's been so good to see you guys. I'm going to go make some lunch. And look forward to hanging out with you guys probably twice tomorrow. So looking forward to it. So happy to be back. And you guys all have a great weekend. Bye, guys.